Sally, looking on the
Sally, straight ahead right here. One more time, one more time. Sally, one big smile. All the way to the right, Dan.
TheGreenGirls.com.
Say all rise.
All rise. On Election Day 2008, Californians voted in favor of Proposition 8, thus rewriting the California state constitution to add a ban on marriage for gay and lesbian citizens who were already enjoying that right. Well, now two lawyers, most famous for representing opposing sides of Bush v. Gore, have teamed up to take Proposition 8 to federal court.
Good morning, Your Honor. Theodore B. Olson on behalf of the plaintiffs.
Good morning.
Good morning, Your Honor. David Boies on behalf of the plaintiff.
Chief Judge Vaughn Walker, a Republican appointee, agreed with Mr. Boies and Mr. Olson that the case could be broadcast, but the defendants, the opponents of gay marriage, turned to Charles Cooper.
Good morning, Mr. Chief Judge. Charles Cooper for the defendant interveners.
Mr. Cooper filed an appeal with the U.S. Supreme Court, which was successful, and the Supreme Court blocked plans to broadcast the trial, and thus the nation was denied access to the testimony of plaintiffs Jeff Zerillo and Paul Katami and Sandy Steer and Chris Perry. But the transcripts of this trial could not be hidden. And on June 16, 2010, the closing arguments of this historic case commenced. These are the words, the witnesses, the testimony, and the trial the defenders of Proposition 8 have fought so hard to keep from public view.
In 1967, that's only 40 years or so ago, we would have punished as a felon in the state of Virginia the president's own mother and father if they had tried to travel there and be married. Now, Mr. Cooper's argument is, and I know why he would like to take back these words, we don't know. We don't have to prove anything. We don't have any evidence. Yet, he was reading from articles written by various persons who did not come into this courtroom and testify under oath, and who did not subject themselves to cross-examination by my colleague, Mr. Boies. Some of them didn't come into court because they had been cross-examined by Mr. Boies in their depositions. But you do have to know. He does have to prove. The Romer Court specifically says, under the lowest standard of review, you have to prove that you have a legitimate interest and that the subject, Proposition 8 in this case, advances that legitimate interest. So how does preventing same-sex couples from getting married advance the interest of procreation? What one single bit of evidence is there that they are a threat to the channeling function? If you accept that California has the right in the first place, and I do not, I believe, Your Honor, that there is a political tide turning. I think that people's eyes are being opened finally. People are becoming more understanding and tolerant. The polls tell us that. There isn't any secret in that. But that does not justify a judge in a court to say, I really need the polls to be just a few inches higher. I need someone to go out and take the temperature of the American public before I can break this barrier and break down this discrimination. Because if they change it here in the next election in California, we still have Utah, we still have Missouri, and we still have Montana. This case is going to go to a court. Some judge is going to have to decide what we've asked you to decide. And you have to have a reason, Your Honor, and you have to have a reason that's real, not speculation, not built on stereotypes, and not hypothetical. That's what the Supreme Court decision tells us. And I submit at the end of the day, I don't know, and I don't have to put on any evidence. With all due respect to Mr. Cooper, does not cut it. It does not cut it when you're taking away the constitutional rights, basic human rights and human dignity from a large group of individuals. You cannot say after the fact, we are going to take away the constitutional right to liberty, privacy, association, and sexual intimacy that we already tell you you have. That is not acceptable. And it's not acceptable under our Constitution, and Mr. Blankenhorn is absolutely right. The day we end that, we will be more American. Thank you.
So if there's nothing further, Mr. Cooper.
Nothing.
Very well. The matter is submitted.
The green girls. Dun-dun.